morning, everyone. I think now pretty much majority of you who are signed up are here. A warm welcome to this webinar today on HR matters around new HR legislation and responsibilities in 2021 in the United Kingdom. My name is Gunnar Larsen. I'm the Managing Director of the Danish-UK Association. And together with my colleague Jay Juvonen from the Finnish-British Chamber of Commerce, who is also listening in here today, we are really pleased to be part of this session with the expertise provided by Goodwill. A few house rules before we move on. You will have noticed that all your cameras and microphones are muted, and they will remain so throughout the session. However, please do not let stop you from posing questions, and for that reason use the Q&A function that you have at the bottom of the screen. Any questions you have, please put them in sooner rather than later, and I will try to moderate those at the end of this webinar. Please go ahead. We already had some in advance. This webinar will be recorded and shared with you all post-event and made publicly available as well for you to revisit and share onwards. Moving on and getting started, I'm pleased to introduce you to the two panelists of today's webinar. We have known Jacqui and Annie for years as the go-to expertise when it comes to HR matters. And both have years of experience in advising foreign companies on how to best structure the UK setup when it comes to HR matters. They are part of a diverse team of experts and advisors at Goodwill, and together they offer a great package of advice and administrative services for, in particular, Nordic companies, but not only. So with that, Jacqui, can I ask you to take the lead from here and start the presentation?
Sure, great. Thanks a lot, Gunnar. So morning, everyone. I know there's a lot of people on this call today who are quite familiar with Goodwill, but for those of you who are not, I'll give you a very brief overview. So we have over 20 years of experience of helping over 1,800 businesses from a variety of industries grow or scale in the UK. We also help our customers understand the complexities of UK business culture. In terms of services, Goodwill services cover 5 departments. So we have governance, finance, HR, payroll, and virtual office. In all of those areas, we have business advisors who are skilled in specializing across those areas, which allow our customers to focus on the things that bring value to their business. Annie and I are present today from our HR department. In HR, we support the full employee life cycle from recruitment to termination. We can service your advisory or administrative needs, but we can also help with elements like training and coaching. We also assist with secondment and sponsorship services. For those of you unaware, secondments are relevant if you are sending overseas employees to the UK from an overseas entity. We work with immigration and tax partners here too to make sure that we're doing everything that's correct from a regulatory side. So Annie and I will be covering a few topics with you today. We'll start with what you need to do as an employer if you have employees in the UK, moving on to what employment legislation changes are coming in 2021, also the post-Brexit implications for HR, the extensions to the coronavirus job retention scheme, and then we'll finish off with how you can prepare your business for agile working post-COVID. So I'll hand over to Annie now, who can kick us off.
Hi everyone, pleasure to be here. Yes, as we do here in Goodwill, we are helping all clients with the employment contracts if needed, and there is quite a few points you need to remember. When it comes to the contract itself, it's very important that you include, for example, stuff like title, salary, start date, training which they need to have done, what kind of benefits they actually are receiving, additional benefits which could be paid benefits, anything to do with pension, that is the percentage as well as the provider, what kind of holiday, if it is including bank holidays, which is different to maybe other countries, also if you can carry forward any holiday. There is clauses on confidentiality, intellectual property, post-termination restrictions, which might be very important if there is a competitive business which you don't want the employee to go straight to. And of course, it is right to work, which is very topical at the moment since we have been through Brexit. This is just a few points which is important in the contract, but as you know, there is quite a lot of other stuff, and for many, the contracts in the UK are very lengthy compared to especially the Nordic countries. When it comes to payroll, the employer needs to set up a pay-as-you-earn scheme as soon as they have employees who's earning more than £120 a week. The pay-as-you-earn is a way for the HMRC to collect income tax and national insurance. When you come to pay-as-you-earn or pay-EYE, as we shorten it to, of course you will then have payments out and you will also have deductions. Payments could then be salaries, bonuses, statutory sick pay, maternity pay, anything on that scale. And then deductions could of course be, national insurance, student loan, and pension contributions. So it varies, it depends from client or employee to employee. The pension schemes, a workplace pension scheme was set up to make sure that employees save for retirement. So each employer needs to put in a certain percentage into the employee's pension on a monthly basis. The pension scheme is a minimum requirement in terms of percentage, and the minimum is 3% from the employer and 5% from the employee. If the employee has an opportunity to earn a bonus in excess of 15%, then the percentage pot will have to increase from the employer from 3 to 4%, but the employee stays at 5. This workplace pension is then a so-called automatic enrollment. The employer can choose to start the pension payment with a 3 months postponement. So that means that on the 3rd month, that's when you start paying it. If you choose to do the postponement, the employees can choose to opt in. Of course, if you as an employer have set a minimum percentage, that is fine. But if you want to make a contractual one where it's a higher level, you can do so, and that will be outlined in the contract. If the employee chooses to do more than the 5%, which is the minimum, that is also totally fine. When it comes to tax and national insurance contributions, if you have an employee who earns up to £12,500 in this current tax year, 2021, then they pay 0%. Anything between £12,501 up to £50,000, then they are taxpayer paying 20%. If they earn more than £50,001, they pay 40% up to the bracket of £150,000. The employers pay national insurance contribution of 13.8%, while the employee, they pay 12% if the amount goes up to £962 per week. Next slide. As an employer, there is other stuff you also need to think about, and that is the relevant insurances. One of them is the employer's liability insurance. That is a legal requirement as soon as you become an employer. Your policy must cover at least £5 million and of course come from an authorized insurer. The employer's liability insurance will help you to pay compensation if an employee is injured or becomes ill from the work they are carrying out on your behalf. If you don't have the insurance in place, you can be fined up to £2,500 per day you are not insured. So this is very important. Other policies we then recommend is a minimum of the disciplinary and grievance policy. It is very important that everyone is treated in the same way in a similar circumstance, and to make sure that issues are dealt with fairly and reasonably, and that you as an employer are compliant with the current legislation. A disciplinary procedure is used by an employer to address an employee's performance and conduct. A grievance procedure is if an employee is raising a complaint or a problem. So it's distinguished. This is a minimum, and that has to be mentioned in your employment contract. The policy itself can then be outlined in the staff handbook. It does not include in the contract, but in the staff handbook. The other policy which is important to have is the health and safety policy. And the key points on the health and safety policy is what is the intent, your aims and objectives. The other thing is who has responsibility for what, and what are the risks and how are they managed. Them two is very important, but of course we have many other policies which might be of interest to you, which could be, for example, anti-harassment and bullying, equal opportunities, anti-money laundering. And we have workshops on various of these topics. So if that should be of interest, please let us know. The right to work, sorry, one more there, yeah, right to work is very important to include in your employment contract. As I said, after Brexit, this is even more important to think about. It is very important that you as an employer check the right for the employee. Do they have the right to work in the UK before you employ them? And the way to do that per today, you could check that by looking at their passport or their national identity card. This can be used up till the 30th of June 2021. As you know, maybe EEA and Swiss citizens who lived in the UK by the end of last year, 31st of December 2020, and the family members can apply to the EU settlement scheme. You might have heard that you will then get a pre-settled status or a settled status. They have until the 30th of June 2021 to apply for this. After the 30th of June 2021, new immigration rules for recruiting people from outside the UK will then apply. You will then need a sponsorship license to employ EEA and Swiss citizens coming to the UK to work from 1st of January 2021. This does not apply to EEA or Swiss citizens who have already employed in the UK. Okay, next, Hannah. Okay, so we have different legislation throughout 2021, which is important. I think I'll just work my way through this. It says here national minimum wage first, which then comes into place now on the 1st of April. And it has then extended to workers aged 23 and over. And it has increased now to then £8.91 from the 1st of April. The other minimum wages are then into year brackets. So up to year 22 to 20 for 16 and 7-year-old and for apprentices. So this is all changing from the 1st. If we look at the family leave pay, that is also changing. So you have family policies here in the UK, which is maternity, paternity, adoption leave and pay, and shared parental pay. And let's not forget statutory parental bereavement pay. All these are changing from the 4th of April, and they then increase up to £151.97 per week. When it comes to maternity, paternity, and adoption, they are entitled to then receive 26 weeks of ordinary leave and 26 weeks of additional leave. And you will then be paid statutory minimum payment, as I say, £151.97 for up to 39 weeks. But you are allowed to take, as you understand, up to 52 weeks, but then the remaining weeks will be unpaid leave. Just to note that adoption leave, only one person in a couple can take adoption leave. The other partner could get paternity leave. Of course, every employer can offer an enhanced package. For example, that you're happy to pay 6 weeks full pay, 3 months full pay, or 3 months half pay. It's up to you how you want to set out that package. When it comes to the shared parental pay, that means that parents can share the leave, which is 50 weeks, between them. And they can share the pay, which is for 37 weeks between them. They can take leave together, or they can stagger the leave between them. When it comes to the statutory bereavement pay and leave, that means that if you and your partner have lost a child under the age of 18 or had a stillbirth after the week 24, you are then entitled to 2 weeks statutory bereavement pay. That came into force last April, which is good. When it comes to statutory sick pay, that is paid when an employee is sick for at least 4 days or more. And these 4 days are including non-working days. And the statutory sick pay is increased now to £96.35 per week. If an employee is sick for more than 7 days, they need to provide a fit note. And that fit note for the 7 days also includes weekends. Employers can offer company sick pay. And you can here again, like the maternity and paternity and the family policies, create your own package. And that could be, maybe you're happy to pay 3 weeks full basic pay. And that could be done either by a 12-month rolling period or in a calendar year. Yeah, I think that's it on this, Anna. Then, when we then move on to the gender pay gap reporting, the gender pay gap regulations 2017 are maybe more known or maybe recognize them as Equality Act 2010. So it came into force in April 2017, and that means that all employers who have more than 250 employees need to report on the gender pay. And this is to find out what is the difference between the women and the men's pay. And due to the COVID situation, the employers now have an additional 6 months after the current deadline to provide the reporting. So everyone can then report now by the 5th of October 2021. Then you have, yeah, Jacqui.
So yeah, now we've got the lovely topic of IR35. So I think this is something that we've been getting a lot of questions about recently. Effectively, there are going to be changes to the off-payroll working rules in the private sector for medium to large size companies. So this is delayed for a year. It was meant to happen last year, but has now been delayed till 6th of April this year. In summary, the existing rules for IR35 still do affect small companies anyway, so you still need to do your assessments there. For those of you who don't know, IR35 is a set of rules designed to assess if a consultant, contractor operating via a personal services company, which is known as a PSC for short, is really that, or if a contractor is actually a deemed employee. And as such, that person or that individual is probably benefiting from a level of tax efficiency. So the existing rules focus on a number of tests. Is a mutuality of obligation for the person to receive work and for you as a client to offer it? Is the contractor able to substitute who carries out their work? What level of control does the contractor have as to the how and where and when they carry out the work? There are a whole list of tests that you can apply. But as mentioned, there are going to be some new rules applied to all businesses except those who qualify as small for the tax year or who do not have a UK connection for the tax year. So you're considered a small company if you meet 2 out of the 3 conditions which are on the screen. All medium to large size companies who are considered to be the end user or client will be responsible for deciding whether the off-payroll working rules apply. And this means that they need to decide whether the individual would be considered an employee if they were contracted with directly. Historically, this has always been the domain of the PSC, but now the end user and client will need to make something known as the status determination statement at the beginning of each assignment with the PSC, and then provide a copy of that to the PSC or the consultant. And this must be no later than the start date of the assignment to be performed or the point where the contract is being entered into. If the relationship is deemed to be found, if it's found to be deemed employment, then income tax and national insurance would need to be applied to fees earned by the PSC. Non-compliance could mean that there could be potential penalties to pay for companies. And for sure, if you do fall into a category of a medium to large size business, then you do need to prepare your business. So identify which contractors are affected, inform them, and then prepare for potentially needing to add them to payroll. There is also the extension to the furlough scheme. Of course, this is the coronavirus job retention scheme, and Annie is going to talk about that later. You just have the next, yeah, great, thanks. Post-Brexit, of course, we've heard about this and it's been talked about to death. There is the loss of freedom of movement from New Year, or New Year just gone. We can only hire, or you can only hire from the existing resident labour market force in the UK. So those who hold a UK passport, who hold residency, or who have pre-settled or settled status. As mentioned by Annie already, if you want to hire EU nationals who were not in the UK by 31st of December, who cannot apply to the settlement scheme by the 30th of June 2021, or indeed non-UK or EU nationals would also be looked at the same, then you will need to become a Home Office licensed sponsor. We are working together with our immigration lawyers to navigate what's a very complex topic, and this affects even short-term business visitors. There are some business activities which do not require a visa or work permit post the 31st of December 2020. The list is quite clear if you read the government paperwork, but just as a short summary, if you have someone that's travelling to the UK from elsewhere in the EU and they're looking to just receive some training, or they're attending meetings or conferences, or engaging in consultation with business associates, or they're maybe doing some marketing research or research and design, attending trade fairs, those sorts of things, they don't need a business visa or to be sponsored at that point, but they will still need to justify why they are in the UK. So you could maybe, give that person a letter from the head office to travel with, just to demonstrate what they're doing, so they can show that at border control. But for sure, they can't carry out anything outside of that list. They can't carry out any work. So in summary, you would need to factor in where you're going to make your future hires, to identify if you can apply for a sponsorship license, and just to be aware that applications do take a while to gain approval from the Home Office. It is a slow process. There's a lot of companies making applications right now, so do factor that into your recruitment plans, and of course the associated costs. And of course we have GDPR. So currently the regulations on UK GDPR and DPA 2018 and the EU GDPR are complementary, but just be alert to the fact that the laws on this may diverge over time. So something that you will absolutely need to monitor. For now, you need to assess your data protection policies for your company and your employees. So things like the data privacy policies, which should have been in place in 2018. So there may need to be some tweaks there. Also, the agreements that you have in place with your suppliers. So identify what sort of data that you process, what the data flows, what direction those data flows are coming in. Is it going from the UK to the EU and vice versa? And also, do you need to have an EU representative for your data needs as well? So really think about what personal data you're processing and where is the key. So over to Annie, and she'll talk to you about the extension of the furlough scheme.
Yeah, hi. If you find it a little bit noisy now, of course I can't control my neighbors, they are doing some gardening. But the coronavirus job retention scheme actually came into place last March, so it's already been a year. As you know, that the government is then helping to pay furloughed staff up to 80% at a cap of £2,500 per month. Changes will come in now from the 1st of July, where the employers need to contribute with 10% of unworked hours. And from 1st of August, it will increase to 20%. In addition to the percentage, they need to pay for pension contribution as well as national insurance. If you are making a claim from 1st of May the employee in question will then have to be on the payroll submission by the 2nd March this year. If it is later than that, you will not be able to make a claim for that employee. So that's very important to make a note of. The furlough scheme, as you might know, is coming to an end on the 30th of September this year. As flexible working has now almost become a norm, and the flexible working we have gone through so far this last year have of course been combined with a lot of childcare, maybe homeschooling responsibilities or caring for elderly. For people back to a workplace fully in the office might not be the thing, and I think people now need to look at a hybrid form of working where actually the employee are splitting the time between work and home life. Flexible working has many benefits, and this has been proved with research and strong evidence on how to actually benefit from this. It gives us a form of inclusion, can help to reduce the gender pay gap, support sustainability initiatives, attract and retain talented individuals, can increase productivity and support the well-being of the employee. These are some of the positive ones. We also know, of course, not everyone is happy to work from home. It might not suit everyone, and then, of course, the workplace will be a better place. But whatever we do going forward, flexibility will definitely be high on the agenda, and we have to remember that the childcare or care of elderly or ill people will definitely be our question going forward. Thank you.
Okay, so Annie's touched on obviously the positives of working more agilely, I guess, and the necessity of having to put in place a risk assessment in your workplace to make sure that that it is a safe place for employees to go. Of course, you know, it's been quite a hot topic recently that there could be some concern about employees returning to the workplace. Or maybe it could be a case of, you know, employees have just enjoyed working from home and maybe they just don't want to go back. And that could pose a problem for some businesses. So firstly, the question would be, thinking about risk assessments, what have you done to make your business COVID secure? So have you carried out a thorough risk assessment? Is there a possibility to social distance? Do you have the relevant safety equipment at work? So you have a duty of care as an employer to provide a safe workplace, for sure. But you also need to think about why you need to have a physical presence in the workplace. So what is your business case for requiring employees to return? Could you maybe support flexible working? Annie did touch upon the positives of that. So, you know, what are the attitudes of your employees? Do they actually want to come back? Has a survey been carried out to identify what their wishes are? We do need to be mindful of our employees' physical and mental health. And again, Annie has been talking about agile working. Most businesses can demonstrate that this has worked in the past and over the last year. So if you do feel that you need full-time or part-time office working and there is resistance from some employees to return to the workplace, then you really need to speak to those employees in question just to see if they've got any genuine concerns. You know, perhaps they have they belong to a clinically vulnerable group, or they live with someone who does, and they're maybe just worried about the effects of the pandemic on that. Bearing in mind that there are some protections under the Employment Rights Act for employees to be protected from detrimental dismissal where they leave or refuse to attend work in circumstances where they feel that they are in danger or where they reasonably believe to be in serious and imminent danger. So in this instance, you would need to think about what reasonable adjustments could be adapted here. And that could possibly be home working full-time rather than actually, you know, being full-time in the office or part-time in the office. So each circumstance may be different. It might be necessary to pay sick pay to employees if they're clinically vulnerable and cannot work from home. The best approach for employers who need employees to attend the workplace is maybe to think about what reasonably practical health and safety measures that they can put in place and communicate those measures to your employees so that they can gain some confidence around their safety. I think communication here is key. Some businesses might want to implement the need for a lateral flow test before a workplace visit. So if so, we just need to bear in mind that the treatment of any data from those tests would be classed as personal data for GDPR purposes. So think about how you receive that data, how is that data stored and retained. If you've done all of that and you have clear documented business case of why at least some workplace attendance is necessary, then you're going to be in a better position to be able to take some action if you're still getting pushback. And of course, there's still a lot of sensitivity around this subject. So we just, obviously treat it with kid gloves. And then if we think about the vaccine, of course, this is quite a hot topic, very divisive at the moment. Currently, employers cannot purchase the vaccine for employees, and they also cannot enforce medical treatment. So that's very important to acknowledge. But if we think about the risks of making the vaccine mandatory in your workplace, would you dismiss the employee if they refuse? So if we think about how a tribunal would look at that, you would need to see whether that dismissal was a reasonable response. So you would need to ask questions of, is there a risk in your workplace? An obvious one would be with your business, or does your business deal with vulnerable people? And are there any other measures that you could have taken instead of dismissal? So could you have made any other reasonable adjustments rather than having an expectation of a vaccine having been received? Also, we need to think about possible discrimination issues. It could give rise to indirect discrimination. So, namely, was this decision affecting a group of individuals with a shared protected characteristic? So we think about pregnant women here who are being advised not to take the vaccine. Are they going to be potentially dismissed because they have refused to take the vaccine? Also, young adults cannot get the vaccine yet. So if these groups were terminated for not being vaccinated, then this could be discriminatory. So I guess the question is, what is reasonable in any workplace on requiring employees to be vaccinated? It's always going to be fact sensitive, and it's always going to be dependent on the risk and implications in that workplace. The higher the risk a non-vaccinated person in the workplace presents to themselves and others, the more reasonable the requirement to have the vaccination becomes. But for the moment, the reasonableness of a requirement to be vaccinated is likely to be difficult to establish in most circumstances. And it's going to be quite difficult to basically adapt a blanket requirement on that. It's not to say you cannot encourage the vaccine to be received. So where an employee maybe cannot carry out their role without being vaccinated, for instance, if the working space is too small to social distance or travel is required, then of course, you can encourage that way. We would suggest auditing the workflows to understand which roles can't be worked from home, which can be performed safely with covered secure adjustments, or if there are any roles where you could reasonably require an employee to be vaccinated, and if so, how would you manage that employee if they refuse the vaccine? So put internal communications in place, make sure that employees are clearly signposted to additional further sources of information and support if they're feeling uncomfortable. Make sure that your safety measures are already in place in the workplace and that you're reminding employees to comply with them. And just think about what will happen on the rollout of the vaccine and how this is going to affect working arrangements if you need to maybe adapt or implement a new risk assessment. And also think about whether you have third parties in your workplace as well. So are you going to have an expectation that third parties will need to be vaccinated before they enter your premises? So you need to make sure that your approach to visitors doesn't undermine your approach for employees as well. And also consider whether day-to-day operations are likely to be disrupted by the vaccine. So if you know that your employees do want to take a vaccine, just think about the fact that they may feel ill afterwards, and how are you going to handle your workplace planning if your employees need to take time off to recover. And of course, as well, as we've got to add GDPR, I mentioned a little bit earlier about data treatment for lateral flow tests. If you're going to be compiling records about who's had a test and so on, the likelihood is that medical records of how employers will treat those will change moving forward. So we just need to give a little bit more thought about how you're storing that sort of sensitive information. Conscious that we've gone a bit of time, so I'll just hand to Gunnar now for questions.
Brilliant, thank you very much. Lots of things to cover here, and I'm pleased to say there's been a lot of questions coming in advance and now, so let's get on to them. to the pension scheme, can an employee choose to opt out from the pension scheme?
Ali, I think that one's for you. You're on mute.
Try again.
Good old technology. No, you're still, okay, I can answer. So yes, the employee, I think the question was, can the employee opt out of the pension scheme?
Correct.
So yes, they can, absolutely. From the first month, then they will receive a letter to say they've been joined to the scheme, and then there will be instructions on how to opt out of the scheme. And that's very core to the rules of auto enrolment.
Okay. And related to that, there was a question from Tom. You mentioned that the employer has to increase the pension contribution from 3 to 4% if the employee can earn a bonus of 15% plus of the annual salary. Does this bonus include sales commission payments?
So this is all to do with bonus and commission. So yes, any kind of extra earnings will then be calculated into this 15%.
Very good. Then we have some questions around remote working. What is the implication of HR for staff to continue working remotely outside the UK?
Well, this one is, so if we're talking about staff who are UK employees, presumably in this instance, who are working outside of the UK.
We would have to presume they are employed
Yeah.
by a UK employer and working outside the UK, yes.
Okay, so presuming this is not pandemic related, then in this instance, then they would need to follow the legislation in the country where they are physically located. So that means for you as an employer, then you need to make sure that they have an employment contract which suits where they are physically located for a duration of time. Again, presuming they're not on a secondment as well, so there's a lot of caveats here. And then they also need to have the right to work in the country that they are physically located at that time. And they would also need to pay tax and social security in that country as well, rather than paying tax and national insurance in the UK. Again, with a caveat that this is not a secondment and they don't have an A1 form agreement.
So you touched briefly upon it. What if it is pandemic related? Is there a difference there then?
Well, again, this is a bit of a minefield. So there was a reprieve for a while for tax and social security, but our understanding at the moment, again, with a caveat that we would need to gain advice on a case-by-case basis. But you know, if someone was working overseas, then they should still really put an A1 form in place if they're a UK employee overseas with an EU country, so they can still remain in the national insurance system. But they should still be able to pay tax in the UK rather than overseas if this is a short-term arrangement for pandemic purposes. Okay,
very good. Is it becoming expected that employers provide additional health insurance to employees?
There is a lot of employees who would like to have the extra benefits when they actually get employed. But what is important for the employer to think about is actually how to attract and retain talent. Could then offering a benefit be of a good bonus for that? And also to look at actually how can I stay competitive in the marketplace? Would then benefit be actually one of the points I should look at? A lot of startups, of course, stay with the minimum required because of the financial situation they might be in, and the focus needs to be on the product rather than the total package they can offer the employees. But I think we could say that 50-50, but you don't have to offer all benefits as terms of private medical, group life, dental care, all that. You can maybe choose one or two. Private medical is very, very popular.
Yeah.
Another good insurance is group life. Group life means the life insurance. So if you sadly should die in service, there will be paid out some lump sum to your nearest.
Yeah, yeah. I think the key thing is as well that generally if companies are brand new to the UK, then there maybe is a little bit of pressure from employees to receive this benefit, but for sure it's not necessarily the norm for a new startup to offer these sorts of things. It's normally once a company matures, then they may start to add additional benefits once they've been in the UK for a bit longer and are more established.
So maybe worth having a look at the industry you're entering to
sure,
see how it compares to your business to attract your staff.
Yeah, definitely. So anything to do with benchmarking, we could also help out with on that.
Yeah, good to know. A question from the Q&A from Katja. How do we as an employer deal with consultants who refuse to visit client sites?
That's an interesting one, and presumably this is maybe part of the pandemic option for the health and safety aspect. The question, I mean, we talk about consultants, so are they employees and are they actually independent consultants is another matter. It's quite a loaded question really, but if we think about employees first of all, then again, as an employer, it's very key that you have a responsibility to make sure that your employees are safe and to acknowledge their calls for concern if they do feel unsafe. So it'd be very important for you as an employer to understand the health and safety risk assessments that have been applied on the client site, because it may be a case that the employee has a reasonable reason for complaints that they don't feel safe. And so if you decided to dismiss, or they decided to resign and claim constructive dismissal or unfair dismissal, based on the fact that they don't feel safe, then that's a problem for you if you've not actually made sure that that the workplace or the place that they're going to is COVID safe.
Good. I'm conscious about time. We're hitting almost quarter past now. Quick two ones. Going back to the furlough scheme, if we employ someone on the 1st of April, will we be able to have the person on a flexi furlough after the first 3 months of employment?
When we then come back to, you can only make a claim from the 1st of May if the employee was on payroll by the 2nd of March. So if the start date is 1st of April, it wouldn't be possible to claim back furlough money from May onwards.
Good. And then the last one from the Q&A. If your parent company is within the EU, but you are a UK registered company, would employees from the parent company require a letter to travel to the UK to work, for example, training, conference, meetings?
Okay, yeah. So I think we touched upon this in the webinar a bit. So the parent company is within the EU, but UK registered company. So yeah, basically you have individuals coming from the EU to the UK, as long as the activities that they're carrying out don't constitute work. So there is a very clear list. Again, we'll be happy to provide that because it's readily available from the data that the UK government have produced. There are a list of activities which are visa-less permitted activities. So we would suggest in that situation that the parent company just produce a nice letter to basically say, this is what this person is in the UK for. They're not doing any work. They are, here to do X, Y, Z. And then that should be okay at border control. Of course, if someone's going on a weekly basis over the next 6 months with the same letter, then that may raise a few eyebrows. But in principle, yes, it should be fine as long as they're not carrying work in the UK.
Very good. We had more questions, but I'm conscious about time. Your contact details, Jacqui and Annie, are here on the screen right now. So I would suggest any outstanding questions, please do use those email addresses there and email to Jacqui and Annie, and I'm sure they'll be happy to respond to that. There was one final question. Will the slides be made available as well with the participants post-event?
Yeah, I believe that Hannah is going to circulate the slides and also a recording for anyone that would like to receive that.
Yeah, for sure. The recording is going to be shared with all of you attending. So for that reason alone, you will have the slides that way through. But of course, we appreciate sometimes it may be easier to flick slides than watching through a recording. Jacqui, Annie, is there some last 30 seconds comments from the two of you before we stop? No, I'm just to say, if you have any further questions, do please reach out and ask. Appreciate there was a lot of information and a lot of detailed information to understand. So if you need some clarity on anything, then do please let us know.
Yeah, and maybe mention our next webinar, Jacqui.
Oh yeah, sorry, I forgot about that. Yes, we have a wellbeing webinar which is happening in April. So we'll be circulating some information on that, which will give you some nice hints and tips on remote working and mental health and so on.
And I can say that we for sure will be sharing that in the next DK UK newsletter as well. I'm pretty sure FBCC will do so as well. So let's round up now, respecting people's time here. Thank you very much. If there are any follow-on questions, you have the details of Jacqui and Annie. You also have here the details, email addresses of Jade from the Finnish-British Chamber and for myself. If there are any particular questions in general or other business issues operating in the UK, do get in touch and we'll be happy to facilitate. A couple of upcoming events I can highly recommend in addition to the one that Jacqui mentioned. But with that, thank you very much everyone for joining today. Hope it has been useful. Please do revisit the recording and come back to us if there's anything we can do. Thank you. Have a good day all.
Thanks everyone.
Bye.
Bye.
Thank you.